Hi everyone, we are from Group 1. Here we'll be explain about intellectual property right in Indonesia. Our group consists of 5 people. The first one and myself, Hendrik Saputra. The second, Ferry Novianto. The third, Sinpen. The fourth, Al Muhajir Razali. And the last one is Aditya Narendra Dwipa. Intellectual property rights are exclusive rights granted by a law or regulation to a person or group of people for their copyright work or property. Why does IPR need to be implemented? Because every right that is classified intellectual property right must have legal force on the work or creation. The purpose are, number one, anticipating the possibility of violating the intellectual property right of other parties. Number two, increasing competition and market share in the commercialization of intellectual property. And number three, as a material for consideration is determining research, business and industrial strategy in Indonesia. The next, Ferry Novianto.
There are two types intellectual property rights. One, copyright. Two, industrial property rights. Copyright is a special right for the creator to publish or reproduce his creation, included in protected works are works in the fields of science, literature, and art. Copyright is granted to works within the scope of the fields of science, art, and literature. Copyright is only granted exclusively to the creator, namely a person or several persons together whose inspiration was born a creation based on thoughts, imagination, dexterity, skills, or expertise as outlined in a distinctive and personal form. Industrial property rights, a patent. Based on Law Number 14 of 2001, Article 1, Paragraph 1, a patent is an exclusive right granted by the state to an inventor for the results of his invention in the field of technology, which for a certain period of time carries out the invention himself or gives his approval to another party to implement it. Patents are only granted by the state to inventors who have discovered a new invention in the field of technology. What is meant by invention is the activity of solving certain problems in the field of technology in the form of process, production results, refinement, and development of production results.
So as we know, intellectual property rights in Indonesia, that has been explained before, there are creator rights, the copyright. And the second one that I'm going to discuss with you is the brand rights. The brand rights as regulated in Law Number 15 of year 2001, that explains in Article 1, Paragraph 1, is containing a picture, word, letters that explains what is the brand. What is the brand of the company that the company owns. And the third one is the industrial design. The industrial design, as we all know, that regulated in Law Number 31 of year 2000, Article 1, Paragraph 1, concerning that the industrial design is related in a matter of industrial design that owns by the industry, especially in a creation of a shape, configuration of composition of lines and colors that has been regulated in Law Number 31, year 2000, Article 1, that defines what is industrial design itself. The fourth one is the integrated circuit and layout design. It is regulated in Law Number 32, year 2000, Article 1, Paragraph 1, that defines what is an integrated circuit layout design. Trade secret. Trade secret that has been regulated in Law Number 30, year 2000, that concerning about trade secrets It explains in the first paragraph, in the first article, that says trade secret is a secret that everyone has not known, especially regarding on a company secret. As we all know, like McDonald's, Oreo, or Coca-Cola, they have their own trade secrets. And the last one is the geographical indication that has been regulated in the law number 15 of year 2001, same as the brand one, that explains in geographical indication are protected as a sign indicating the area of the origin of an item.
There are four principles of intellectual property rights. 1. Economic principles. 2. The principle of justice. 3. Cultural principles. And 4. Social principles. Intellectual property rights case in Indonesia. 1. In 2015 until 2021, government has been recorded to have handled about 1,184 cases related to violence of intellectual property rights in last 5 years. And then the number of valuation has made Indonesia still hold the priority watch list of PWL status in terms of intellectual property, thus hampering investment. What has government do? In 2001, the government of Indonesia passed law number 14 of 2001 concerning patents and law number 15 of 2001 concerning brands in mid 2002 concerning copyright, which replaced the old law and was effective 1 year after promulgation. And the latest government released Omnibus Law, which has contained rules of intellectual properties. What is part intellectual property rights that include in Omnibus Law? There are change the patent law and then change the rules of the trademark law.
Impact of Omnibus Law to intellectual property rights. Small business, especially micro, small, and medium enterprise, only need to register through the online single submission to register their business. The electronic license system with OSS that will be implemented can avoid illegal lapse or extortion and corruption in the bureaucratic process, because the entire licensing process has been disintegrated electronically. Omnibus law also makes the formation of a limited liability company in Indonesia known as PT similar and without any minimum capital restriction. It's the same with patents and trademarks, where the process is accelerated. With the eyes of business licensing, the governor hopes to improve the investment ecosystem and business activity. So this is from our group, the topic of Indonesian property rights in Indonesia. Thank you very much.